Good morning. Welcome to Santa's Legal Workshop, our last Sharpe Minds of 2025. For those who don't know me, my name is David Leach. I am the Senior Associate in the Employment team, and I am joined today by my colleagues Christian, Manasvini and Medina. And we are going to do a roundup of some of the interesting cases that we have seen in 2025. As well as a look forward to what is coming early 2026. Obviously, for anyone that was watching the LinkedIn news last night, there have been big changes now confirmed within the employment law sphere. So, as I said, we're going to have a quick look at employment cases and updates and how they've grabbed the headlines, the status of employment law as it currently is, as well as obviously what it will eventually be. And then at the very, very end, obviously, we've got a quiz for you all to take part in if you so wish, just to see some of the interesting things that have come along. So I will now hand over to my colleague Manasvini, who is going to talk through some of the interesting cases that we've had in 2025. Manasvini.
Yes, so I'll be talking about tribunal cases from 2025 that you'll never believe. We've rounded up 3 bizarre cases and lessons that employers can learn from them. So the first case is Torre v Commissioners for HMRC. In this case, following allegations of harassment at work, Miss Torre was signed off with stress. She had requested that only essential correspondence should be sent to her, and if so, by email. Her manager told the tribunal that he'd kept a list of team members' birthdays and would often arrange cards to be sent from the whole team if it was a special birthday. The previous year, Miss Torre had asked to be removed from this list as she preferred not to celebrate for personal reasons. Once she was on sick leave, Miss Torre requested that her employer should have minimal contact with her during her absence, as stress exacerbated her symptoms. However, she received 11 emails and a birthday card over the 3-week period. When this case was finally taken to the Employment Tribunal, the tribunal ruled that HMRC's repeated contact during Miss Torre's absence constituted unwanted conduct, creating a hostile and intimidating environment for her. As while she could have been more proactive in reporting her absence, she had clearly explained why she wished for correspondence to be kept to a minimum. As a result, in March 2025, the tribunal awarded Miss Torre over £25,000 in compensation, which included £20,000 for injury to feelings. This case highlights the importance of ensuring that if an employee is on long-term sickness or raises a formal grievance, that employers ensure they follow a full process and ensure that this is dealt with correctly. Next slide, please. The next case we will be looking at is Rook versus NHS Blood and Transplant. Over the course of her employment, Miss Rook had raised multiple concerns with her employer relating to donor safety checks and training standards, which she believed posed health and safety risks. Following these disclosures, a team-building Myers-Briggs type personality assessment was carried out while Miss Rook was absent. Rather than using her own input, a colleague completed the assessment on her behalf. The resulting personality type was labelled Darth Vader and made public to all her colleagues. The tribunal found that this association with a widely recognised villain would likely cause distress and that the incident was a detriment, meaning that it caused harm or a negative impact to Miss Rook. The claimant was made to feel unpopular and suffered from a low mood and anxiety in relation to her work environment as a consequence. The tribunal ruled that while the employer had not breached the implied term of trust and confidence or discriminated on grounds of disability, it had treated Miss Rook detrimentally because of her protected disclosures. This included refusing her request to withdraw her resignation and taking actions that undermined her professional reputation. Miss Rook won her case for detriment after a protected disclosure, but lost claims for unfair dismissal, disability discrimination, and a failure to make reasonable adjustments. She was awarded over £28,000 in compensation in a remedy hearing in February 2025. This case clearly highlights the importance of handling whistleblowing disclosures appropriately and ensuring that employees raising such concerns are not subjected to retaliatory treatment. Even if other employment claims, such as discrimination or unfair dismissal, do not succeed, employers may still face liability for a whistleblowing detriment. The next slide, please. The final case we will be looking at is Lanushka versus Accountancy MK Services Limited. In this case, Miss Lanushka's employer installed spyware software on her work computer. Subsequently, over 2 days, the software recorded Miss Lenushka spending around 1 hour 24 minutes on personal websites, including Amazon, Very, and Rightmove. Relying solely on this monitoring data, the company dismissed Ms. Lenushka for engaging in private business activities during working hours and for breaching the company's code of conduct. No disciplinary hearing took place and no prior warnings were issued. Subsequently, Ms. Lenushka brought a claim for unfair dismissal. The Employment Tribunal was critical of the employer's handling of the dismissal, highlighting several procedural and substantive failings, such as the fact that she had permission to use her work computer for personal matters during quieter periods and her lunch breaks. And also the failings of the company to investigate the extent of Miss Lenushka's internet use, as some of her browsing was actually found to be work-related rather than personal. Furthermore, the fact that there was no disciplinary hearing, no warning, and no opportunity for Miss Lenushka to respond was severely emphasised by the tribunal. Combined with Miss Lenushka's clean conduct record, the reason for dismissal was therefore found to be unfair. As a result, she was awarded £14,000 by an employment tribunal earlier this year. This is a cautionary tale for employers about the risks of dismissing employees for the personal use of work equipment. The judgment reinforces the importance of fairness, transparency, and process in all dismissal decisions. Occasional personal use of work devices will rarely justify dismissal unless clear and consistently applied policies are in place. Employers relying on monitoring software must go further than simply presenting data. Proper investigation and input from the employee is essential. So there we have it, lots of important lessons to learn. That's a roundup of the most interesting cases of 2025, and I'll now be passing on to Medina to discuss the current trends we're seeing.
Thank you. Now, moving on to some of the laws which came into effect this year. First up, a big win for parents. So since April 2025, if your baby needs neonatal care, you can take up to 12 weeks of paid leave, and that's on top of maternity and paternity leave that you already get. Next up, holiday pay for irregular hour workers. The new rules allow rolled up holiday pay. So instead of complicated calculations, you'll see holiday pay included in your regular wages. We also had the Equality Act, which had clarified that sex means biological sex. This affects policies around gender identity and same-sex facilities. And finally, from December, which we've seen, the early conciliation period has doubled from 6 weeks to 12 weeks. This means more time to resolve disputes before heading to the tribunal. Next slide, please. I will now be handing over to Kit, who will be providing some extra examples of trends we've seen.
Yeah, thank you, Medina. So the trends that I'm going to look at are some of the developments that I'm seeing in active cases that I've had across 2025. And to be honest, I would label most of these trends as very frustrating for employers. So the first trend we're seeing is a rise of ChatGPT and AI-generated systems being used by litigants. And we're seeing this at various stages of the employment cycle. So, for example, in a grievance or a disciplinary process, it's common to receive a subject access request from the employee. We're now seeing those employees rely on ChatGPT to generate arguments and justifications for why they should receive further documentation and to coordinate how it should be received. Then the submission of claim forms, it's pretty clear to me when I've got a ChatGPT ET1. It follows the same style, and I'd say it's about 40% correct law. It's very frustrating to respond to and often doesn't reflect the reality of the situation. It's only as good as the prompt put in by that individual. And then moving through the litigation life cycle, that individual will rely upon ChatGPT to generate correspondence with myself. I personally don't think it should be a substitute for good legal representation, which of course is not accessible for many claimants, but the result is we get very confused cases where perhaps the claimant doesn't quite follow exactly what's being generated by whatever AI algorithm they're using. I also believe it is increasing the workload of employers, because previously, while there might be a simple exchange related to the points the claimant clearly understands, now it's being expansive and touching on areas that previously the claimants might not have considered. The second development, again, it's not new to 25, but it's certainly a continuing trend, particularly in discrimination cases. The claimant has the ability to add an individual respondent to the claim. So as well as bringing a claim against whatever council, local authority or employer, they may also raise a claim at the same time against potentially their manager if they're alleging discriminatory conduct. Again, this is a difficult trend for employers to defend. Often I see it being used as a way of leveraging pressure upon the employer, whether it's for a settlement or just in litigation generally, because of course tribunal judgments are public. So even if there's a successful defence, there will be a claim against not just the local council, but that individual manager being named, which adds to the stakes of the claim. Kath, next slide, please.
Yes, just before we move on, just on the AI point, I think as well is it might also be tempting for employers to respond via AI, and I think it's just a health warning with everything, because even judges are being criticised for using it to do a summary for a judgment that they have written, and then they've done a summary. So I think it's just touch it with a barge pole if you are going to use it.
Yeah, that's completely right, David. Again, another frustrating trend for employers. Again, for many people on this webinar now, it will not come as a surprise to you that there is a long wait period when you enter employment tribunal litigation. However, it's become really noticeable in the last year. Often what will happen is we will receive the ET1, the claim form, and at the same time the tribunal will list the preliminary hearing. After you submit the response to defend the claim, effectively the next step will be the preliminary hearing, and there shouldn't really be too much happening in between ordinarily. However, these preliminary hearings are being listed in 2027 and potentially even beyond. So effectively, a claim will go in and there'll be no action for a year, and then you're looking at least another year to take it to a substantive hearing. So this long wait period means it'll be difficult to obtain documents, the memory of witnesses will be impacted. When an individual respondent might be named or might personally be quite heavily involved, they'll have the weight of a employment tribunal claim being placed against them for a longer period. So it adds to the stress for the employer. On the other hand, I also think there are benefits to the employer. For example, there'll be litigation fatigue for that claimant, because whilst it might take them an hour to submit a basic ET1 via the tribunal's online system, when they're faced with the reality of multiple years of litigation, having to wait before they even find out an answer, it potentially increases the possibility for a settlement if appropriate, or even them withdrawing the claim because they simply don't want to take it all that way. Final point, disability remains a very difficult claim to defend. So under the heading of disability discrimination, you've got failure to make reasonable adjustments, discrimination arising from a disability, direct and indirect discrimination. Now, we have a lot of sympathy for employers because often, particularly with local authorities, you will take substantial steps to put in place effective reasonable adjustments where appropriate for an employee. However, simply a delay of a couple of weeks in providing equipment that might support an employee may be sufficient to find there's been a failure to make reasonable adjustments, and you can be looking at a 5-figure award just for the delay, and therefore it is difficult to defend. It's not to say it can't be defended, but out of the claims that we routinely defend, disability discrimination remains the difficult one for employers. So those are my trends that I'm continuing to see in 2025 and expect to see in 2026. And I'll pass on to the next slide. Thanks.
Thank you, Kit. So April 2026 is shaping up to be a big month for employment law in light of the big development yesterday. Firstly, family rights gets the boost. Paternity leave will be available from day one. So there will be no qualifying period, and unpaid paternal leave will also become a day one right. So new parents won't have to wait to access these benefits. Next, statutory sick pay changes. The waiting period is now gone. So SSP starts on day one of the illness, plus lower earnings limit is scrapped, meaning low paid workers who previously missed out will now qualify. And this is a big step towards inclusivity. A new player enters the field, will have the Fair Work Agency. This enforcement body will have powers to inspect workplaces, issue penalties, and even bring claims on behalf of workers. So compliance here isn't just about good practice, it's really about avoiding enforcement action. And finally, redundancy consultations. If employees fail to consult properly, the protective award doubles from 90 days to 180 days. That's a serious financial incentive to ensure consultation is right. And as of October 2026, we'll introduce the second wave, and this includes sexual harassment duties, where employers must take all reasonable steps to prevent harassment, plus liability for harassment by third parties will also be back. So clients and contractors will also count in this category. And we also have union rights, where employers must inform workers of their right to join a union, and recognition and ballot processes are simplified through this. Next slide, please.
Thank you, Medina. So just quickly on following on from last night, obviously that should now say the ERA, not the ERB. But obviously, yes, unfair dismissal is changing. Granted, that's 2027, but it's the end of 2026. It will now be 6 months for unfair dismissal. Currently, it's 2 years. So really do review your probation policies. You've got a year to get those sorted, updated, and make them as effective, as efficient as possible. Reporting of sexual harassment is going to become a protected disclosure in and of itself, and that's probably actually a good thing. People are still scared to raise it in the workplace, and it just gives people the extra benefit of some further protection. So I think, again, other things you should always be keeping in review is, do you actually have a safe and secure way for people to raise these concerns? Not necessarily to their managers, but to other people that then this can take action. And obviously that goes hand in hand with the fact that the third party rights are coming in, protection against third party harassment. Obviously we are waiting for regulations on that. It is going to be slightly more watered down than the all reasonable steps, but still something very, very important to look at. And now kind of more the coal in people's stockings that is coming, along with unfair dismissal going to 6 months. Those that have been keeping up to date with the ERB, the last minute change from the Labour government was compensation cap has been removed in its entirety. So this means that instead of the year's salary, or I think it's currently 114,000 and change that you could possibly get, it's now anything and everything goes. So for those who are high earners that are always subject to the cap, I think that's at least potentially good for them as employees. For businesses, it's potentially going to make things a lot harder, as settlements are no longer going to be easy to work out, because people could basically say, well, I can just go to tribunal and I could get 3 years of salary, multi-million-pound pension claims, and other things as well. So whilst we've had a habit of seeing £1 million schedules of loss, which have got not worth the paper they're written on, they are now probably going to be worth the paper they are written on. So it could make things difficult. Again, I think that's planned to come in January the 1st, 27. So obviously it's still a year or so out. For those that are involved in public procurement, it's buried away in the Employment Rights Act as a change to the Procurement Act, which basically requires harmonisation of terms on a public sector procurement, whether that be an outsourcing or a service provision change, to basically no less favourable treatment on terms. We are still not entirely sure what that means. No one seems to be sure what that means. But the big concern is there's no carve out for public pensions. And obviously that is usually seen as a good beneficial term. So it could mean you've got one person on a public sector pension transfers across, and 99 other people could be demanding to be admitted to the LGPS. So very much watch this space for regulations to come out early next year. believe there'll be consultations on that, and I think a lot of businesses, local authorities and lawyers will be piling in on that consultation. I certainly say keep an eye out. For those that work in the public sector who might be aware of the process of check-off, this is where employees can ask their salary to be sacrificed for their membership fees, and it's paid directly to the union, and then the union pays an administrative fee back to the employer for that duty or that work. That right to charge the union is going. So again, if you want to allow check-off, you might want to consider actually, is it financially beneficial for you, and potentially stop providing check-off. Obviously, employees can still pay their unions directly. It's not stopping that. And as Medina's also said in her slide, obviously industrial action is going to be getting a lot easier going forward, with timeframes extending and potential ballot requirements reducing. So I think it's certainly a space to be watching for the next 18 months to 2 years. So I will then hand over to the last slide before we move to the quiz.
Thank you, David. Now, turning to some headline appeals to look out for in 2026. Firstly, we'll have the case of Miller and University of Bristol, which concerns whether Professor Miller's anti-Zionist beliefs are protected under the Equality Act, and whether his dismissal was because of those beliefs or the way he expressed them. In 2024, the Employment Tribunal ruled that his beliefs were protected and found the university had directly discriminated him by imposing a disproportionate sanction. The university appealed, and the case was heard by the Employment Appeal Tribunal in 2025, with the judgment reserved and expected in 2026. If upheld, the decision will confirm strong protection for political and philosophical beliefs and highlight that employers must distinguish between belief and conduct. If overturned, it could narrow the scope of protection and give organizations more discretion in managing controversial expressions of belief. Next up, we'll have Bailey and Stonewall Garden Court Chambers and others, which arose after Alison Bailey, a barrister, claimed discrimination and victimization under the Equality Act following complaints about her gender-critical views and criticism of Stonewall's diversity champion scheme. The Employment Tribunal ruled in 2022 that gender-critical beliefs are protected and found Garden Court Chambers had discriminated and victimized Bailey. Though Stonewall was not liable, now heading for appeal in 2026, the AT will consider whether the tribunal correctly applied the law and the extent of liability for organizations influenced by external bodies. If upheld, the decision will reinforce a strong protection for gender-critical beliefs and require employers to balance diversity initiatives with freedom of belief. If overturned, it could narrow that protection and give organizations more discretion in managing complaints about expression. And lastly, we'll have Groom and Maritime and Coast Guard Agency, which concerned whether the employer met its duty to make reasonable adjustments under the Equality Act for a disabled employee, particularly around remote and hybrid working arrangements. The Employment Tribunal found that the agency failed to make adequate adjustments amounting to disability discrimination and emphasized that reasonable adjustments should reflect modern working practices. The employer appealed to the Employment Tribunal, arguing that the tribunal had misapplied the test for reasonableness and that requested adjustments were disproportionate. Judgment is reserved, and the outcome is expected to clarify how far employers must go in adopting roles for disabled staff and whether remote working should be considered a standard adjustment. So this one is really a big one to look forward to in 2026. And over to David now for the second portion of our webinar.
Brilliant. Thank you very much, Medina, and everyone else. Before we move on, say thank you very much and Merry Christmas to everyone and a Happy New Year. And thank you for working with us in 2025. We look forward to working with you in the future in 2026. Also, if you have any ideas of things you would like us to cover, obviously the next big thing for us is covering the Employment Rights Act and how that's going to impact over the next 18 months. But if people do have any suggestions for things they'd like us to cover in upcoming Sharpe Minds, please do let us know. And of course, we're happy to introduce that in our platform of talks.